A very good morning to all my dear students. So I hope you have gone through your previous acts. Indian Contract Act, Sale of Goods, partnership is also what we did last time. Also, you must have done negotiable instruments in LLP. And now today we are going to have a quick revision of Companies Act 2013. So before we begin the session, as I always love telling you the quotation, success usually comes to those who are too busy looking for it. So as you all have been working hard, I know that you're going through the recorded lectures. I request you children, keep making your notes along with whatever you're listening. Study material is the Bible for you. Read each and every line from the study material, underline wherever it is required, and in all the lectures, whatever you're listening from the teachers, where they are asking you to write few things, please make a separate notebook for law. Your notes really help you in the last days. You just have to flip through the pages, whatever you have highlighted, underlined in the study material, just go through the entire stuff just before the day of the exam. So the preparation for that D-Day has to start from today itself. So keep making notes and keep practicing, keep doing all these things properly and stay focused and determined. All right, with this note, let's begin our today's session about the Companies Act 2013. Now, what is a company? So before that, as I always tell you, hard work and determination is equal to success. So remember, children, nothing comes easy. We cannot say that, CA, now they have made it thrice in an year. Even if I did not clear now, I will give it again. Then also you have to be focused. How you have to go by the things, how you have to keep the track of the things, how you're making a timetable. So the main key to success is your consistency with hard work. Try to complete the task, whatever you have assigned to yourself within the time allotted. Sir, there was a request for sharing the remote control to Ashok. So I have given it to them and now the screen has started sharing on its own. Excuse me, sir, at the back end, Nisra. Technical support, Ashok. Who is that person? All right. So the tips for the CA Foundation students is, number one, we were talking about the hard work. Now, many of you keep asking me about the study plan. So it's very important, please, children, make a timetable and study. You ask us about the writing of the answers. So it's required day one, start practicing within the time allotted to yourself. Say, for example, if you're practicing a question of case study related, give yourself a time period of 7 minutes. Timer lagao. Dekho whether I'm able to complete in those 6-7 minutes or not. If you have given the target of 7 minutes, try writing and completing it in within 5 minutes. All right. So MTPs, RTPs, and memory game, I call it. So just revise the entire content. Only after you have revised and read the whole chapter, you have learned it, then only jump to the RTPs and MTPs. Don't children start opening revision test papers without revising your content. Obviously, you will feel nervous. And then students come back to me and tell me, ma'am, mock test paper, I did not understand what the examiner is asking. Because you have not revised what is required to be done before that. So it's important you revise it and then you shift to the RTPs and MTPs. Now let's begin with Companies Act 2013. So we'll try to cover the features. I have divided the session into two parts. First 1 hour, we'll be completing the first half of the chapter, and second 1 hour, we'll be completing the second half of the chapter. Along with that, I will also take up your queries as and when they come. So features, you all know, you have done the features and characteristics of LLP. So LLP and companies are almost on the same platform. So how the company was incorporated? You remember that there was an individual who was a sole proprietor, entire liability he had to bear, and then he decided to join hands with someone and form the partnership form of organization. After forming a partnership, we understood that we still had a huge unlimited liability. So what did we decide to form? After having partnership, when we were having unlimited liability, government came up with a new ruling. Leah has given up the new form of organization. What is the name of that? Yes, you're right. LLP, Limited Liability Partnership. Further, in order to expand the business to a great extent, we thought of setting up of a company. Company can be a public company or a private company. So that company, we are going to understand what is the company. Company has a corporate veil theory. The very, very important part of company is a corporate veil theory. That means company is different and its members are different. There is a shield which exists between company and its members. So company is liable for its own acts. Whatever the liabilities of the company are, company will have to bear it. And whatever the liabilities of the members are, member have to bear. You cannot say that if company has suffered a losses, one of the shareholder sitting at home will be called up, please come and pay for the company's liabilities. No, company pay the liabilities on its own. Company has a separate legal existence. So that is what we're going to understand in a short while in the features. And then we'll be doing the types of companies. Memorandum and articles will be taken up in the next 1 hour session. So to begin with the features of the companies, the first feature of the company in itself is definition. You all know, children. It has 470 sections, 7 schedules. This is how the act is made. Company is an incorporated association, which is an artificial person created by law. So company is not an individual, but it is an artificial person which comes into existence by getting itself registered. It has a perpetual succession as well as a common seal. So all this definition, one of the definition you can learn from this, examiner might ask you 2 marks question, define a company. So Professor Hanning has given the definition. It is basically the summing up of the features of the company, which is again very easy to learn. Talking about the applicability of the companies, it is applicable to all the companies which are incorporated under 2013 as well as previous law means because Companies Act were earlier 1956, we were following that Companies Act. So whatever companies were formed under that respective act, to that also Companies Act 2013 will be applicable as well as to insurance company, electricity company, banking companies, to all these companies, Companies Act is applicable except where their own act is dominating, there they will follow the provisions of their respective act. So company has a body corporate. Can you see these big, huge buildings? It seems as if we have landed up in Dubai. So like you have seen tall buildings in Dubai, we see, or in Gurgaon, or in Bombay, or in Hyderabad, high-tech city. These are all company structure. So you have a body corporate. The body of the company is not an individual. It is a legal existence. So we cannot say that this building is a company, but the company is just trying to show you the picture that the companies have its name like Tata, Reliance, and they have a perpetual succession. What is the meaning of perpetual succession? Come on, tell me. It's a revision class. We're not here to study each and every concept. Let me see how well you have studied. So why I'm not getting any revert from the students in the admin query? Yes, Miss Ishika. What is the meaning of perpetual succession? Yukta, Anushka, Ishika Singla, Simmerpreet. Good morning, everyone. So what do you understand by perpetual succession? It means, very good, Yukta, existence of the company is not affected by the coming or going of the members. Company will not get dissolved even after the death and retirement. That's absolutely correct. So perpetual existence means the company has a lifelong existence. The company has to be closed. Winding up of the company only has to be done by making an application to the tribunal, or the name has to be strike off from the registrar of companies. Next is your separate legal entity where the company has been clearly told it is separate from its members. Makora versus Northern Assurance Company Limited is an important case law, children. You can refer the case law. You can give a reference of this case law whenever you have been asked about the separate legal entity concept. Artificial legal person means the company can own its own property. The company can file a case and also the case can be filed against the company. It can also enter into contracts because you get a legal existence. Suppose XYZ Limited company has come into existence. Now you can have rent agreements, contracts with the name of XYZ Limited. But it is acting always through human agencies. Companies cannot start walking on their own and go and do business. Always there is a human agency, directors, shareholders who are behind the screen, who are running the functioning of the company. And then we have a common seal. Again, there is an option of having a common seal. If you opt to have a common seal basically means your signatures, the stamp that we put for the company's official signatures. Or if you're not opting for common seals, then any document of the company shall be signed by two directors. And if you have a company secretary, then one director and one company secretary should be signing. This is also a very common question generally asked in the MCQ. So common seal also, you should learn who is required to sign the important documents of the company. Talking about the limited liability, when we go to the types of companies, company limited by shares, limited by guarantee, there I will explain you the entire concept of limited liability. As of now, you can simply remember liability of the company is not unlimited. It is limited up to the extent of the company's assets. Now, I've already told you corporate veil theory, shareholders are different and company is different. There is a veil which is existing between both of them. Can the veil of corporate personality be lifted? So there are few cases, there are 5 cases in which the corporate veil can be lifted. Now, what is the meaning of lifting of the corporate veil? Child, when I told you that the company is different, shareholders are different. So there is a very important underlying case law of Salomon versus Salomon and Company Limited, which told us that the members of the company are different from the liability of the company's actions. Let's have a quick revision of Salomon versus Salomon. So Salomon was a person along with his 7 family members. He has set up a company known as Salomon and Company Limited. Now, when this company went into liquidation, Salomon himself was also the secured creditor of the company. Now, my dear students, you know, when the company is winding up, the secured creditors needs to be paid first, then the unsecured creditors, and whatever balance is left will be taken by the owners of the company. Now, since Salomon was also the secured creditor of the company, his share was given back to him. So the angry creditors went to the court. The case was taken up as a Supreme Court judgment. So it was taken up in the Supreme Court, and a case was filed that Salomon himself is the owner. Why he is taking the money of the company? So the case was resolved. The corporate veil theory came into existence. Supreme Court judgment came and it said Salomon is different and company that he has formed is different. He's not getting money because he's the owner. He's getting money because he's the secured creditor of the company. So even if you're a secured creditor of the company, even if you're the owner, then also you can claim the money because company is different and shareholders are different. It also tells you that the members should not be liable for any errors of the company. They enjoy corporate insulation. Corporate insulation means company has its own identity. So that is the leading case now on the basis of which a company is separate and distinct from its members. This foundation of corporate veil theory was laid down. Now, what happened, children? People started taking, misusing this kind of thing. They started taking the advantage of corporate veil theory. They were creating companies for improper conduct, for doing certain frauds and illegal things. And whenever the case used to be filed, they used to say, please go and hold a company. That is responsible. I'm not responsible. But my dear students, tell me something. I just told you who is running the company. It's you as a human agency who is running this company. So law said, let's formulate certain cases. Whenever a rule is made in law, we always have certain exceptions in order to cover any loopholes which are left. So that the people cannot misuse this corporate veil theory, these 5 exclusive reasons have been given where the corporate veil is lifted. And when we lift the corporate veil, means company and shareholders will be treated as one. So what are the cases where the company and shareholders will be treated as one? Yes, very good. Ishika Singla has written it correctly. The cases where the company and members will be treated as one, those are the determining the character of the company. So Daimler versus Continental Rubber Tire Company Limited. This was a very interesting case law in which it was held that the alien enemies cannot have a contract among themselves. So there was a company which was a German-based company and it was having a contract with England-based company. So when during the World War situation, there was a war between Germany and England, it was held that they cannot contract with each other. Then these contracts will come to an end. Why? Because corporate veil is lifted. And even if it was held in this particular case, so what happened was they said that they're the German citizens, but the company is England-based. So, but the company was being run by the German citizens only, na? So this is German citizens means it's a German company. You cannot say that's an England company. The people who are running the company, so they were from Germany. So Germany and England were not having cordial relationships at that time. So that's why they said that you cannot trade with alien enemy. If such kind of things is happening, corporate veil will be lifted and any contracts with the alien enemy will come to an end. To protect the revenue. What is the leading case law in this case? Dinshaw, Maneki, Pettit. You must have seen in the videos also, we have done n number of questions from this particular case law. It's very important and examiner's favorite. Most of the time, case study comes from Dinshaw, Maneki, Pettit case. Now, what this Mr. Dinshaw was doing, he was earning huge income by the way of interests and dividends. Now, obviously, when you earn income, you have to pay income tax on it. You have to pay the revenue to the government if you're earning huge incomes. So in order to avoid paying the taxes, what he did, he removed his income from the profit and loss account. He invested this income into 4 different companies, 4 private companies he formed, and he invested his entire income into this, and in return took a loan from these companies. So he was just doing a circulation of money. He deposited the money and then he himself took it away as loan, and that loan was never repaid. So it was held that these companies are created as a sham, means just to create a fraud. They are not doing any kind of business or purpose. So Dinshaw was held liable, and it was held that Dinshaw himself is the owner of these companies. Corporate veil was lifted, and it was held that in case any person is trying to avoid any taxes, anybody is doing fraud with the government, then that company and the owners will be treated as one. Third and fourth are related to avoiding any legal obligation. Say, for example, whenever you have the profits in the business, you're supposed to pay bonus to the workers. As per the Bonus Labor Laws Act, you have to pay the bonus. So again, these owners of the company, they were creating subsidiaries in order to avoid paying the bonus to the laborers. So this kind of situation is also avoided. Even if you are holding the subsidiaries to act as your agents, then also the corporate veil will be lifted, and your subsidiaries and you as yourself as the owner will be treated as one company. And the fifth one is the most interesting, that is forming the companies for any fraud or improper conduct if you're doing any illegal activities. Another important case law that you should remember is Guilford Motor Company versus Horn. So till now, we have referred 5 case laws. Number 1 is Macora versus Northern Insurance, where it is trying to tell you that the company and members are different. If you'll refer to the case law, I have very detailed discussion we have done in that. Stop scribbling on the screen. Very detailed discussion we have done on this case about the Macora versus Northern Insurance. That is how you cannot have the insurable interest also in the property of the company. So in that case, you have to remember property of the company is different, owner's property is different. Then Salomon versus Salomon Company Limited is a leading case law which defines the foundation of the corporate veil theory. And then these 3 case laws, you must remember the name. Examiner is never going to ask you to write the entire theory about the case laws, children. Never write a wrong case law. Never write a wrong section in your paper. Better don't write it if you don't remember. But if you give such kind of references, correct references, it gives a very good impression. Like if you're talking about trading with the enemy, you are mentioning correct spellings, Daimler Company Limited versus Continental. So you have understood that the alien enemies cannot contract, you can give its reference. If any case comes for the private companies are being formed, money is being transferred, loan is being taken, Dinshaw Maneki Pettit Company case law reference can be given. And the fifth important case law for today's session is Guilford Motor Company versus Horn. Now, what happened? Guilford was a person who was working as an employee. Mr. Horn was a person who was working as an employee in a company. And when he left that company, there are certain restrictions. If you would remember, under Section 27 of the Indian Contract Act, you're given certain restrictions that you cannot trade in the same name in which you were employed, or you cannot solicit or attract the customers of your previous employer. Now, this Horn formed a company and he started soliciting the customers of the old company. So, angry Guilford Motor Company filed a case against Horn. He said, you have formed a company and now you're trying to cheat us. You're trying to do wrong things with us. You're doing fraud and illegal activities. So, you know what Mr. Horn said? He said that go and get hold of my company. You know, company is different. I am different. I am a shareholder. I'm a member of the company, and there is a corporate veil theory on the basis of Salomon versus Salomon and Company. And company is different. I am different. So go get hold of my company. So they said company is acting on your actions. You are the man behind the company. So in such cases, corporate veil was lifted and Horn was held liable for his illegal activities and misconduct. Is that clear? So it's 11:20. Let's for 10 minutes. We'll again do certain types of companies we'll be doing, and then we will jump to the query sessions. All right. So first important base types of companies is company limited by shares, limited by guarantee, and unlisted companies. So what is the meaning of company limited by shares and company limited by guarantee? Let me just take up these types of companies from study material also, because you have lots and lots of information given in the study itself. So corporate veil theory, incorporation, all these kind of things we're going to do today. So we have done all these corporate veil existence also discovered. Children, don't scribble on the screen. You're not small students. Please be grown up. All right. Now, these are the 5 cases which we have just discussed, how the corporate veil is lifted. Now, classes of the companies on the basis of liabilities. So, company limited by shares means in case with the company you have invested the shares, their liability of the company is limited by the memorandum on any amount unpaid on the shares held by them. The liabilities of the members in case of a company limited by shares is held liable up till the amount unpaid on the shares. Means, say for example, if you had a share of rupees 10 per share, and now you have paid up till rupees 8 on this share. So how much amount is pending? So rupees 2 per share is still pending. So your paid up capital was rupees 8 and rupees 2 is still pending. So now tomorrow, whenever the liability of the companies occurs, so there's too much scribbling on the screen. Somebody from technical assistance can help me. Miss Sarat, sir. So if this liability of the members will be limited up till the amount of rupees 2 per share. All right. So whatever amount is unpaid on the shares, only your liability will be up till that amount. So in case of a company limited by shares, you are liable only till the amount which has not been paid on the shares and not beyond that. Shareholders will be contributing only to the extent the amount which is unpaid. So rupees 2 is unpaid, only that amount can be called up. And where is the liability mentioned? Second thing you have to remember is memorandum of association will state the liability of such members. Now moving to the limited company limited by guarantee. Now guarantee is a fixed amount where you have given the fixed amount. So you have said that I will undertake to pay rupees 10,000. B says I will undertake to pay rupees 20,000. C says I will pay 15,000. Now, as and when the liability of the members will occur, A will be liable till 10,000, B will pay till 20,000, C will pay till 15,000. So whatever amount you have guaranteed means the fixed amount that you are, the sum which is mentioned in the memorandum. Again, the liability is mentioned in the memorandum and you cannot be called upon to pay beyond that amount. Whatever amount you have agreed, only that amount you need to pay. The only difference is both the amounts are mentioned in the memorandum. Only difference is that in case of company limited by shares, you will be called to pay the liability anytime during the continuation of the company. However, company limited by guarantee, there you can be called to pay the amount only at the time of winding up of the company. So you can write down in case of a company limited by guarantee, in case of a company limited by guarantee, you can be called to pay the amount at the time of winding up of the company. And in case of company limited by shares, you can be called upon to pay the amount anytime during the continuation of the company. Now, there's another reference Supreme Court judgment, Narendra Kumar Agarwal versus Saroj Malu. Not very important case law from the examination point of view, but again, since everything is given in a study material is very, very important for us. So definitely we will have a quick go through. It says, generally the company limited by guarantee children are the companies which are charitable kind of organizations. How their funds are made? The funds are made by endowment, fees, donations, charges, all these kind of things. And now, when such companies come into existence, their liability will be asked only at the time of winding up. All right. So, in case of a company limited by guarantee, it carries certain privileges than from the ordinary shareholders. Here, in case of an ordinary shareholders, you will be held liable any time during the lifetime of the company. But in case of a guarantee company, you have to wait only till the end. When the company is winding up, then only your liability will be coming into existence. Then only you will be called upon to pay for the funds of the company. Here, no working funds are needed. Only the endowment fees, donations, whatever charges are given is required in case of a company limited by guarantee. Clear? Unlimited company, its name itself suggests that the company's liability is no limit. There is no limit means unlimited liability.
Harleen?
Yes, ma'am.
Wait for 2 minutes. Nisarg? Some student is doing scribbling on the PPT. Now, kindly see it.
Ma'am, continuously he is doing
And
it.
there is a student, ICI Zoom from the name he has joined 8256113723. Dear student, please join from your name. All the students have joined from their name, but there is one student now. I think he has removed, or Nisarg, you have removed him. Okay. आप meanwhile देखिए क्योंकि ना he is constantly doing the scribbling on the PPT. Okay. Yes, Harleen, you can continue, please.
All right, ma'am. So unlimited liability company, there is no limit. As the name itself suggests that there is no limit on the liability of the members. Liability ceases when he ceases to be a member. So as long as you're a member of the company, you will be liable till the unlimited amount. Liability is not unlimited till the company is not moved up. Now here also the liability will come into existence only at the time of winding up of the company. So very important in case of a company limited by guarantee, also the liability comes up at the time of winding up of the company. In unlimited liability also, the liability will be called upon only at the time of winding up of the company. So there is only one company which is required to contribute during the existence of the company, that is company limited by shares. Is that clear, students? Now let's move to another very, very important concept, that is OPC, one person. Yes, Yukta, in case the members, if in case the person has given the guarantee and the person has died, his legal representative will become liable in case of a death of that person. That's correct. OPC in case of a one-person company. One-person company children has been introduced to encourage the entrepreneurship and corporatization of business. So I was a sole proprietor. I want to do business, and now I can't do the business at a very large scale because I'm just an individual. I'm a sole proprietor. So I want to have the legal existence. I want to have the legal entity, and I want to enjoy the limited liability structure of a company. So government has given us a ruling. Section 2, subsection 62 was included under the Companies Act 2013. So a new concept was introduced that only one person having as a single member as a person can also run a company, which is known as one-person company. So again, one-person company, point number one, you can write down it has a separate legal entity. Please mark it. Point number two, they have limited liability. However, in sole proprietor, you have unlimited liability. OPC has a limited liability. Okay. It is a simplified procedure for OPC. It is a private limited company. Very important. So if in MCQs I ask you OPC is a public company or it is a private company, so always remember OPC is a private limited company. What is the minimum share capital? As of now, no limit has been prescribed, but whenever they tell you the limit, that will be the applicable limit. Now, the important point of OPC is OPC will always have the name of the nominee in its memorandum. Who is the nominee? In case Mr. X, suppose Mr. X has opened up the company. Mr. X opened up the company to run as OPC. And now if Mr. X dies tomorrow, his nominee will be required to take up the entire charge about his business. So you can remove this another child who is scribbling on the screen. Kindly remove him from the... Yeah, but I don't know how come he's joining again and doing the scribbling. Children, please grow up. You're CA students. Don't scribble on the screen. So nominee is a person who will be taking care in case the OPC person, Mr. X, dies, then entire control will be the hand of nominee. So it is very important to have the name of nominee. Say, for example, Mr. Y is the nominee whom we have named in the memorandum. Now, this whose person name has been given, that is Mr. Y, will also file his written consent with the ROC that, yes, I have agreed to act as a nominee. And also he can withdraw his consent. Means tomorrow he can decide to withdraw his consent that now I don't want to act as a nominee. Member of OPC can at any time change the name of OPC also. So now I have Mr. Y who is acting as my nominee. He can withdraw his consent also, or Mr. X himself. Member of OPC means here he is talking about Mr. X. Mr. X can also go and change Mr. Y to Mr. D. So he felt that I am not very happy and not very sure about Mr. Y. I want to change my nominee. So simply he has to give a notice to the company and file it with the ROC, and he can also change the name of the OPC. Any such change will not require any alteration in the memorandum. You simply need to intimate the ROC. So these third, fourth, fifth, sixth, all these points are related to the nominee. You can write down in your study material. These are nominee related points. Number one, you will name the nominee. Number two, his consent should be taken. Number three, he can be given a right to withdraw his consent. Number four, you can change the nominee also yourself. And any such change will not be alteration. Only an intimation needs to be sent to the ROC. Now, who can be a nominee? This is again a beautiful MCQ question, one of the examiner's favorite. ICAI enjoy giving this question to the students, and it is a very important question. Who can be a person who can open up an OPC? Number one, a person who has stayed in India for not less than 120 days. If you're having old study material, it was 182. Please erase it 182. The latest provision is for 120 days. Then only he can incorporate a OPC. Also, to be a nominee, he should have stayed for 120 days. So if I ask you, Mr. X stayed for 110 days, can he open up an OPC? No. Mr. Y, who was a nominee, he stayed in India for 109 days. Can he be my nominee? No. So 120 days, both for the OPC person and the nominee, both is the condition for 120%. And no person can open more than one OPC, and neither he can be the nominee in more than one OPC. Only you can open one OPC, and you can be member as a nominee also in one OPC. Further, the conversion cannot be converted into any public and private companies. Also, NBFCs cannot be OPC. You cannot open a non-banking financial investments by having the name of OPC. All right, children. So these are the simpler words. Again, your study has briefly given the summaries also. For revision, you can revise it from this. But for learning part, all these point of nominees, 120 days condition, everything needs to be learned. Now, private company and public company are very, very simple. Private company tells you that the minimum paid up share capital, how much it should be, and it restricts the right to transfers. The limit on the number of members is 200. So you can write down minimum number of members is 2 and maximum number of members will be 200. This is what you have to remember in case of private company. And the persons who are employment, they are not included. They're not included in the number of 200 members, and also who were the previously who were in employment, they also. So all the employees and also the previous employees will not be counted as the members, and jointly shares which have been held will be counted as a single member. So if there are 20 shareholders who are jointly holding the shares, they will be counted as 10 members. So 2 shareholders holding 1 share, so they will be considered as 1. So if you're having 20 shareholders jointly holding, they will be counted as 10. So this is the provision relating to private company. It prohibits his invitation to the public. Obviously, it's a private limited company. You cannot go and ask, you cannot issue a prospectus and go to the public for asking the money. However, there can be a private placements where you can raise the money, but that is part of the CA Inter. Abhi, you just have to remember that you cannot go to the public for inviting the money. So this is the significant points. Some summary has been given very beautifully in the study material. Just learn these 6-7 points. There is prohibition. Right to transfer is also restricted. Small company is always a private company. Can I have a small company as public company? No, ma'am. Small company is private company. OPC can be a public company. No, ma'am. OPC is always a private company. How many members? 200, excluding the present employees, plus members who were earlier employees, and joint members will be treated as 1. बस इतना ही learn करना है. Okay. Now, small company is the major thing where you face a problem. Children, small company definition that they have given 10 crores and 100 crores. Please read it beautifully. They have amended over here from 15 September 2022. Again, a latest amendment has come, which has said that minimum paid up share capital and turnover has been modified to 4 crores and 40 crores. So in your study material, you can simply see it is writing here 50 lakhs and 2 crores. You can simply amend this amount. You can write down over here where it is written 10 crore. Please cut it off and write 4 crores. And here where it is written 100, just cut it off and write 40 crores. So if your paid up share capital is less than 4 crores and your turnover is less than 40 crores, then you become a small company. This is not applicable to holding and subsidiary. Section 8 company can never be a small company. It is a charitable kind of organization. It can never be a small company. All right. Now, public company also, simply you have to read these points. It is not a private company. The shares are freely transferable. You can transfer your shares freely in case of a public company. Private company में नहीं कर सकते. Public company में you can freely transfer the shares. No minimum paid up capital requirement. Minimum number of members are very important. 7 as the minimum number of members in case of public company and no limit on the maximum number of members. Now, only important point is subsidiary of the public company is deemed to be a public company. So say, for example, you are a private company, XYZ Limited. XYZ Private Limited is a private limited company. Now, if this company is being held by ABC Limited, ABC Limited is a public company. So public company uses the word limited after its name. Private limited company uses the words private limited after its name. So if ABC Limited is holding XYZ Private Limited company, then the company will deem to be a public company. If it is a private company which is a subsidiary of a public company, then this company shall also deem to be, means मान लिया जाएगा कि this company is also a public company. So any company which has been formed for lawful purposes having 7 or more persons can be treated as a public company, and subsidiary of such public company will always deem to be a public company. I hope no doubts here. Sir, we can open up them for the doubts if they want to ask. Any doubts still here, students? Yes, resident of India, and the person should have stayed in India. So, Yukta, resident of India as per income tax is different, but here you simply have to remember the provisions of 120 days for the OPC person. All right, I'm glad if everything is clear till here. Let's move to holding and subsidiary. Now, holding and subsidiary again has a very beautiful definition. Let me just open it from my study material, from my presentation. So this is your public and private company basic notes. You can simply learn it from here also. So if you're controlling the composition of the board of directors, or you're having more than 1/2 of the total voting power. So if I'm holding more than 50% of the voting power or shareholding in another company, then first company is considered as a holding of another company. Say for example, A is holding more than 50%, not 50%, it says more than 1/2 of voting powers means more than 50% of the shares of B Limited. So who will become holding and who will become subsidiary? If A Limited is holding more than 50% share capital of B Limited, then which is holding? A Limited becomes the holding company and B Limited becomes the subsidiary company. Or if I say A Limited is controlling the board of directors, means A will decide how the board of directors of B will be appointed, how they will be removed, how B Limited directors will be behaving. Then also A Limited will become the holding company and B Limited will become the subsidiary. Very good. Correct answers, those who have given. So now moving on to the holding and subsidiary. The subsidiaries of subsidiary company will also be considered to be subsidiary. So A is having a subsidiary B, B is having a subsidiary C. So C will also be the subsidiary to the major parent company, that is A Limited. So associate company is very, very important. Generally, question comes from associate company rather than holding subsidiary. Holding subsidiary is also important. We have a very interesting case study which we have done in the lectures previously about Popular Books Limited. So you must go through that case study. It gives you a very nice conceptual clarity about your holding and subsidiary. Significant influence means you are having a associate company, means you're having a significant influence, but you're not a subsidiary company. Here, the percentage has to be seen as at least 20% of the voting power control, or if you are participating. So the word is or, children, please remember. So if A Limited is participating in business decisions of the B Limited, then A Limited and B Limited are associate companies. If A Limited is having 20% of the voting power in another company, then A and B are associate companies. If he is having 30%, then also they are having associate relationship. If having 19%, then no relationship. So for associate, 20% relationship, till 20 till 50 is the associate company relationship. Beyond 50, it is holding and subsidiary relationship. And also any joint venture is included. So if A and B are doing a joint venture, they are also considered to be the associate company. What is the difference between listed and unlisted companies? So here it is a national stock exchange, which you all know. We have two different stock exchange, Bombay Stock Exchange, BSE and NSE in India. So all the securities which are listed on the recognized stock exchange are known as listed companies, or they are in the process of the agreement of listing. So those which are still in the process as per the listing agreement, they will not consider to be the listing company. Only the securities which have been listed on stock exchange, only those companies are considered to be the listed companies. Other companies which are not listed or are in the process, they will be considered as unlisted companies. In case of government company, how much share should be held by the government in order to call it a government company? You tell me. You have revised your sessions. Please tell me how much shares shall be held in case to call it a government company. Why only one child is answering? What about others? Very good, Yukta. Very good, Ishika. 51%. We have so many students live with us. Others are not answering. What happened? All right, 51% of the share capital. Very good, Anushka. So at least 51%. So 50% condition is in holding and subsidiary in case of a government company. Not less than 51% means at least 51 and beyond has to be seen to be held by the government in order to call it a government company, whether by central or by state government or partly by both of them, then also it is called as a government. Now, what are Section 8 companies? Section 8 companies are the companies, foreign companies are the companies registered outside India but having a place of business in India. So if ABC Limited has been registered in Singapore and it has a place of business in Delhi, it will be called as a foreign company. So CA Inter whole of the chapter on foreign company has been made up for you. Very good. Section 8. Section 8 companies are companies which are talking about the charitable kind of organizations for promotion of commerce, sports, art, education, all these kind of things, charitable objectives. Section 8 companies are open. So Section 8 companies also I will take up from the study material. So this is your 4 crore and 40 crore small companies. What are dormant companies? Dormant companies and Nidhi companies. Children, dormant companies are the companies which have been formed for a future project. So I have opened up a company, ABC Limited company today, but I have not done any kind of business in it. So you get the status of dormant company status. And Nidhi companies is also very important because there have been an amendment for the benefit of Nidhi company. Mutual Benefit Society means a company. Again, central government will declare a company to be a Nidhi company. These are the companies which have been formed for the mutual benefit of society, means people from the society can be benefited mutually from this. So you and me decided to open a Nidhi company. We will be contributing the funds to the common pool. And as and when there is a requirement, we can take the money from our savings. So Nidhi companies have been formed in order to inculcate the habit of savings, encourage the habit of savings among the people. And what are the public financial institutions? LIC, IDFC, all these kind of the public financial institutions. Let me just take up Section 8 companies, then we will take a small break after Section 8 companies. So what are Section 8 companies? Section 8 companies, first of all, please remember, now I'm going to make it very, very brief and easy for you. Just keep marking whatever points I'm going to tell you. Section 8 companies are the companies. First, this is the definition that you have to learn. They are the charitable companies for promoting commerce, art, sports, trade. How their profits have to be used? Their profits have to be used only for promotion of its objectives and not to pay the dividend. Write it in your own hands. The profits of these companies are to be used only for promoting its charitable objectives like art, sports, science, religion, whatever they want to promote. But they should not be paying dividend to its members. Write it with your own hand. Prohibiting means they should not be paying. They cannot pay dividend to its members. Section 8 companies are like FICCI, SOCHAM, National Sports Club, CII. All these are the examples of Section 8 companies. Now, who will give the license to Section 8 companies? Central government will issue the license. All the other companies are getting the registration done with ROC, but central government has the power to issue the license. Only when you get the license from the central government, then only you can operate as a Section 8 company. Otherwise, you cannot operate as a Section 8 company. And they are not required to use the word private limited or limited. They are only the companies with the limited liability license has been issued by the central government. Registrar will register such persons under this section and then they enjoy the same privileges as of a limited company. Now, when does the license get revoked? Central government may revoke their license anytime if they found that some fraud is happening, this company is no violating the objectives. Say, for example, if you have formed a company for promotion of sports, so you're encouraging the people to do a basketball match, you're sending students from here and there, you are a charitable organization, but you started paying dividends to your members, you started eating the profits from the company, or you started charging very high rates to the people instead of a charitable, you are started doing some fraudulent activities, then your license will get cancelled and central government will send a written notice, opportunity of vote will be given and your license will get cancelled. An order of central government will be considered the final order. He can also request you to amalgamate yourself with any other company and form a single company, or merger can happen. All these points are given very beautifully over here. Section 8 company significant points you have to simply remember. This is the purpose of it. Form minimum requirement of share capital. There is no requirement as of now. Only small company has given you the requirement. Other companies have not given any minimum share capital requirement. Using the profits for promotion, do not declare dividend. License has to be taken from central government, not to use the words. License can be revoked if he feels. And on revocation, what is going to happen? Simply learn this. He will either convert its status. So if you have done any kind of things damage, your name will be converted either into private limited or limited word will be added to your name, or the finding of the company can happen, or you will be amalgamated with another company having similar objectives. So there is ABC Limited, which has violated the provisions. There is DEF Limited, who is running the same sports business. You might be amalgamated into that company and your own existence will come to an end. For calling a general meeting, 14 days notice has to be given. Now, children, this types of notice, general meeting, this is entire part of your CA inter-syllabus. But section 18 simply tells you that otherwise 21 days notice is required, but the privilege has been given to the charitable companies that only 14 days notice can be given instead of 21 days. And there is no requirement of independent directors, minimum number of directors. Even the shareholders relationship committee, remuneration committee is not required to be formed. Another important point which MCQ can be asked or examiner can ask you, partnership firm can be a member. So generally partnership firm is not an artificial person. It is the collaboration of all the partners together. But Section 8 company is the only company which allows the partnership firm to also join in as a member. So if I ask you, there is Mr. A, B, and another company which is entering, whether you can act as a member in that company or not, then you have to tell them the requirement that partnership firm, if it is acting, joining in as a member, that can also act as a member in Section 8. All right. Okay. So let's take a small break here. We have done the types of companies and then we will be moving ahead to the second part of the chapter. All right, let's take a small break. All right. So welcome back, students. You're right, Yukta, where you have mentioned that you cannot have dividend paid by Section 8 companies. That's correct. So now let's start with the incorporation of the company, how the company is basically incorporated. So for incorporating a company, you need to have certain documentation which needs to be filed with the ROC. The major two important documents of a company are MOA and AO, Memorandum of Association and Articles of Association. These are the most important public documents which are to be signed and filed with the ROC. Just in few minutes, we'll be doing the topics MOA and AOA. You will understand in detail what is memorandum and what is articles of association. Apart from that, there is certain declaration requirements. You have to get your declaration signed by the promoters. A CA will sign a declaration, chartered accountant, that this all the requirements have been filed. The first directors will also sign. Everything is in correct place. What is the objective of the company, name, address, everything of all the promoters and directors will be shared. Application needs to be filed with the ROC. And all the persons who are named in the articles as subscribers will also be filed with the ROC. And after ROC is satisfied that everything has been well managed, it will issue a certificate of registration. So ROC will be issuing the incorporation certificate. A SIN number is given, that is corporate identity number. All right. And in case of any false information has been given, in case of any false information has been given or fraud is occurring, then the tribunal can order the company to wind up. Okay. All right. Yes. Any false information, if it is coming up, tribunal. Now, what is the meaning of false information? Suppose the directors are giving the wrong name. The name of the company is such that it has already been registered. For example, if you have taken up the name ABC Limited, there is already a company with the name of ABC Limited, and then the such kind of cases, tribunal can order for the binding up of the company, or it can take an action for removing its name. Also, the actions against 447 can be taken if any company is trying to cheat or create a fraud. So 447 is very important. When you go to CA Enter, you'll be understanding more about 447. It is basically regarding the fraud provisions. Any false information or fraud thing is being done, then the company will be liable under 447. Now, earlier it was all the application things, all the public documentation kind of things had to be done, and the company gets registered by filing the things. Nowadays, the things have been simplified. We all know we are doing the things electronically. Even at a click of a button, when you order Blinkit, Amazon is coming and delivering you the things at home. So similarly, the company incorporation has also been very, very simplified. You can use a SPICE form, that is simplified performer for incorporating company electronically. So here you can set up a company by filling up an electronic form. This is for ease of doing the business. And after registration, the company will get the legal personality structure with the perpetual existence. So once the company has been registered, it gets the legal personality and the existence of the company as having a perpetual existence. All right. So now let's quickly do a very interesting question that I promised that I will be doing one case study question with all of you. So ABC Limited was registered as a public company and it was having 245 members. Now you will be surprised to know this is basically the CA Inter question, which is given in the CA Inter book, the first chapter, the second question that has been given in descriptive case study. And this kind of question has come in your exam. So it's very, very easy, very, very interesting. And just try to understand how important it is to understand the relevance of public and private company. बहुत थोड़ा सा उन्होंने स्टडी में दिया हुआ है, just the number of members, and a proper 4 marks case study has come on. So don't leave a single line from a study material. Anything can come up from your study material. So there were directors and relatives, 190 employees are 15, and there were ex-employees who were having the 20, and others are 10 joint holders. So when I say 10 joint holders holding the shares jointly, so how many will be counted as these 20 will be counted as 10. So now there are 190 members, 15 employees will be counted or not? Yes or no? Ex-employees and employees, will you be counting them as number of members? Yes, ma'am, or no, ma'am? Quickly tell me. No, ma'am, they will not be counted. That is absolutely correct. Yukta, Anushka, Ishika, all of you are correct. So 190 members and 10 will be considered as the joint holders. So total number of members is only 200. Therefore, no reduction in the number of members will be required in order to convert. Very good, Tanishka. That's correct. So no reduction is required. Now, how to attempt this question? Now, why I have taken up this question? Answer is very simple. That no reduction is required. Ma'am, they will not be. But likhna kaise hai? Paper mein, examination mein, how we have to present, that is very important to understand. So first of all, you'll write in the given case, ABC Limited is having this many numbers. Directors have proposed. So I'm giving the facts of the case. So first define that what is a private company. Private company by its articles restrict the number of members to 200. So you have defined that this is the provision to which it is related. Give them that the joint holders will be treated as single members and employments and all these are not to be. So this is the provision of the act. Provisions I have defined. Now I'm giving you the facts that the company. Facts is the summary from the question itself. Examiner has given you the question, you're just making a summary, you're doing facts of the case and your analysis. So you have written the facts, these are the number of members, joint holders. Now following are the members, directors and the relatives and joint holders will be constituting 200 members. So this is your analysis. So conclusion you will write on the basis of above analysis and provisions, we conclude that they can be converted without the reducing of the number of members. Is that fine, everyone? Again, the 6 marks question has come. Explain charitable purpose companies. How will the revocation of license happen? So whatever we have discussed from the study material, all the points have to be mentioned about Section 8 companies. Okay, let's take up another case. ABC Limited has allotted equity shares with voting rights to XYZ Limited, 15 crore and non-convertible debentures, 40 crores. Now the total paid up capital is 100 and non-convertible debentures are also there. So what is the meaning of associate company and are they associate company? Yes or no? So now when you read the definition of associate company, it has clearly mentioned that total paid up capital will include the equity paid up capital and the preference share capital. It is not mentioning about the convertible debentures. So 100 crore is the total capital which they're having. So 20% if you're controlling out of that. So how much is the 20%? They are holding only 15 crores. As allotted the shares with the voting rights, so only up to the amount of 15 crores. So now out of 100 crore share capital, so this is holding equity as well as preference have to be included. So out of the total, it is 20% has to be seen. So out of 100, 20% is there. So only 15 crore requirement is being met. Therefore, the amount of holding of share capital is less than 20% and they will not be held as the associated company. Do we have to consider any relevance of non-convertible debentures? It says holding and allotment of non-convertible debentures has no relevance in finding out the associate company relationship. What is required in associate company relationship? The aggregate of the paid up share capital and preference share capital. Is that clear? All right. Now moving on to the topic of classification of capital, how the capital needs to be classified. So this is something which you have been doing in your accounts, balance sheet sessions. You have been saying how the capital is to be classified, issued capital, nominal capital, subscribed, called up, and all these categories of capital. So the major chunk is your authorized capital, which you have thought about starting the business with this maximum amount of capital that you have decided you have kept for your business is your authorized or the nominal share capital. Out of that, children, how much you have decided to issue to the public? When I take up a prospectus, I issue that this is my issued share capital and I invite the public for subscription. Say, for example, this my authorized share capital is rupees 10 crores. And now I've issued to the public rupees 6 crores. Suppose public has subscribed to 5 crores of share capital. So now this is my major business, which I'm doing with the 5 crore because public has accepted the invitation to subscribe for the 5 crores of share capital. Now this 5 crore of share capitals include 50 lakh shares of rupees 10 each. Now the called up capital was rupees 10. But if the people have just paid rupees 8 per share, if people has just paid rupees 8 per share, then 4 crore will be my called up capital. The amount called up will be 5 crores I have called up and the amount paid up will be rupees 8 per share. So how much the amount has been paid up is your final share capital, which appears in the balance sheet. So whenever you want to make any kind of investment in a company, the paid up share capital is something which needs to be seen. Generally, the issued and subscribed capital is same. The authorized capital, nominal capital is same. Issued and subscribed is same. And paid up capital is how much the shareholders have paid up. That is the capital with which the company is running and doing the business. Now, what are the different types of shares? Equity shares and preference shares. Can anyone tell me what preferential rights are given to the preference shareholders? They are given two types of rights. Number one, the preference share capital get the right for the payment of the dash. And number two, they will get the, yes, fixed dividends. Very good, Yukta. And they will also get the repayment of capital. So whenever the business is winding up, they will be repaid the capital first. So this is the preference that is given to the preference shareholders. And what are equity shareholders? Equity shareholders are number one with the uniform voting rights and number two with the differential voting rights. So differential voting rights is another very, very important thing that we have to remember. That is DVRs. So uniform voting rights means I have one share in your company, I get one right. I have 10 shares in your company, I get 10 rights. But DVRs means after having 10 shares in your company, I will get one right. So you'll get lesser right by holding more share capital. Now, why this is given? Because they have more higher rate of dividend. The rate of dividend is fixed, but the shareholding rights that have been given, they are different. So Tata Motors came up with this DVRs in 2008 and they said that 10 shareholders will be getting 10 shareholding. You will get one right, but the fixed dividend rate is little higher. When you go to CA Enter, you have full-fledged DVRs, how they are issued, what are the reasons, how the resolution needs to pass, entire thing you will be doing over there. As of now, see, students in CA Foundation, we are laying the foundation, we're laying a basis. So Companies Act, we're just introducing companies to you. What is the company, how it is formed, how the things are happening, how it will be functioning. So in CA Inter, you will be doing at length about the companies. We have just started with it from foundation, just few pages, but those few pages are very, very important. We are understanding all the important case studies, how the share capital is defined, what are the different types of share capital, what is memorandum, what is articles. You'll not get the repetition of the same in your Inter. So Inter, we'll be talking about these terms. Section 8 companies will be spoken about. You will be knowing the meaning at that time. All right. Going ahead, moving towards the topic of memorandum of association. Okay, now your turn. Can anyone tell me what is the meaning of memorandum of association? What is the meaning of memorandum of association? Is the memorandum an important document or it is a public document? What is the memorandum? Memorandum is a charter of the company. Very good. AOA is the internal document. Very good. Yukta is studying very well and she's answering. So I'm very sure that you will get great marks. What about others? Ishika, it is an important and public document. Okay. Tanisha, it is the power of the company. Very good. And Kirti Mathi, you're not answering. Simarpreet, what do you mean by memorandum? Shravika, all the others who are there with us, please answer. What is the memorandum? It is the main important document. So it is the document which describes the objectives of the company. So what is the company into, how the business is being run, how the shareholders and creditors and everyone powers and activities that has to be given, where the money of the company is to be used. All these things are written in the memorandum of association. So you have 6 different clauses in MOA. Number 1, name clause, office clause, object clause, liability, capital, and association. What is name clause? Name clause will tell you what will be the name of the company. What are the words which you cannot use in the name clause? Tell me. Let's have a quick revision. Can we use the word king, queen, empress, prince, princess? Anything which is related to the government cannot be used. Also, the persons dealing with the company is already very good, very good, very good. Correct. No is the correct answer. All of you are giving the correct answer. So what is the registered office? The place where the office will be set up. It will be describing the entire thing, how the office has to be set up. Again, section 13, we do it at length in extension, in inter, but here you just need to know what is the registered office clause. When you're filing the documents with the ROC, you have to tell the name and place of the office where the place will be stated. And this name will be mentioned in the MOA as well. Objective of the company is very, very important, children, for MOA, because MOA will decide what objective the company is into. Say, for example, if I have opened up a company, ABC Limited, and I am into sale and purchase of cloth, then I can only do that kind of business. I cannot do outside the purview of my memorandum. Tomorrow, if I started purchasing shoes instead of cloth, then it is ultra vires my memorandum. You cannot do anything which is beyond your memorandum. You can only do the objective for which the company has been formed, and that objective is clearly given in the MOA of the company. Liability clause again defines your three types of liability: limited by shares, limited by guarantee, and unlimited company. All these kinds of liability clause has been defined under the liability clause of Memorandum of Association. Capital clause will write about your detailed maximum amount authorized share capital will be mentioned, or the nominal share capital will be given over here. And what is the meaning of association clause? Association clause will tell you the number of members you are having, and very important thing that has to be included in the association clause is name of the nominee who is opting as a nominee for OPC. If you're having OPC, the name of the nominee will also be mentioned in your memorandum of association. Is that clear, students? And unlimited liability clause will be mentioned in articles. Memorandum, limited liability means liability will include limited by shares and limited by guarantee. Both the things have to be mentioned over here. Now let's move to the most interesting topics, that is about your doctrine. Three important doctrines we are trying to do. Any doubts till here? Anyone have any queries they want to ask, any questions, you can ask over here, because then we will be moving to a very different topic, that is doctrines. Any problem in types of companies, anything, it is already considered that. Yes, Ishika, that's correct. Yukta is saying crystal clear, ma'am. That's wonderful. Thank you so much. I'm glad you're enjoying the session. Okay. So what is the meaning of doctrine of ultra vires? Company cannot go beyond their powers. So memorandum has given me certain powers, certain objectives, and I'm supposed to act within those powers and objectives only. I cannot go beyond that. Anything which is done beyond the powers of the company, okay, symmetry, that's great. Everything is clear. Good. Ashbury Railway Carriage versus and Company Limited versus Rich. In this case, what happened in this case law was, if you want, we can have a detailed discussion about this. I did not understand liability clause. Okay, Tanishka is asking about the liability clause. So let's open the study material and let's discuss in detail about the liability clause. So this is what is mentioned about the liability clause. This all you have to learn, children. Incorporation of company and what happens on registration. Just go through the case laws. Junjunwala basically tells you all these case laws given in the registration of company. They tell you that once the company has been formed, company becomes an artificial legal existence from its members. Company will have a separate legal entity and a limited liability. सारे केस लॉज में सेम यही एक कंक्लूजन निकाला हुआ है, बट यू शुड गिव इट अ फेयर रीडिंग. इट्स नॉट समथिंग वेरी इंपॉर्टेंट टू लर्न. Coming back to the limited liability clause tells you that what will be the liability of the members. If it is a company limited by shares, then your liability is limited up till the amount unpaid on the shares. So if I have 10 rupees share, I have paid up 7 rupees. So now my liability can only be called for rupees 3 per share. I cannot be called to contribute beyond that. And in case of a company limited by guarantee, I can be called upon only to pay the amount that I have given the guarantee. So your amount undertakes to contribute to the assets while he's a member, or within 1 year he ceases to be a member. So I can contribute as a guarantee only when I'm a member, or within 1 year when he ceases. So once he ceases to be a member, his contribution will be required only for 1 year. Or the liability is contracted before he ceases. So whatever liability I've contracted while I was a member, I will be liable to pay for that. And the cost, charges, and expenses are the right to the contributories among themselves. So whatever, when the company is going into winding up, children, company limited by guarantee is trying to tell you that I will be required to contribute only at the time of winding up of the company and not during the lifetime of the company. Is that clear? Unlimited liability, Ishika Singla, when I told you about types of companies, unlimited liability, the liability is mentioned in the Articles of Association. Remember, I told you 2 points of difference. In case of limited by shares and by guarantee, the liability is mentioned in the Memorandum of Association. You can refer to that. And in case of In case of unlimited liabilities, their liability is mentioned in the article. So this is association clause. OPC, name of the nominee, has been added. Now you simply don't have to read each and every line from here. You can simply underline ultra vires is beyond the powers. You cannot go beyond the powers of the company. Anything, memorandum is a public document. Anyone who is acting a contract with the company is bound to have read this document. That is known as doctrine of constructive notice. That means, for example, Mr. X comes and deals with my company. So he's bound to read my memorandum. Then only he should enter into a contract with company. Let me give you a very interesting situation. There is a company ABC Limited, which is into shoemaking company. Okay, we have a very big company which is into making shoes. Now, Mr. X wants to make a contract with my company for the sale and purchase of clothes. Can Mr. X do that? Mr. X is bound to read my memorandum of association. So when Mr. X will read my memorandum, it will be clearly written that the objective of the company is to make shoes. How can he come and make a contract with the clothes? So even if ABC Limited has signed this contract and they have agreed that we will make a contract, they are not bound to do this. Here, who will be held liable? No, he cannot transact. That's correct, Ishika. But who will be held liable? X will be held liable. Very good, Yukta. Very good, Ishika. Outsiders will be held liable for anything that you're going ultra-wise. Means whenever you're trying to go outside the preview of your company, the outsider who is doing a wrong dealing with your company will be held liable and you will not be held liable. Tanishka, that's correct. X will be held. Very good. All right. So company can neither be sued nor sued upon the ultra-wise transaction. So ABC Limited can never be held liable. It is Mr. X's fault. He should have read the memorandum before doing a contract. Now let's move to the Ashbury Railway Carriage versus Rich. It says the objective of the company was to sell the railway wagons or railway carriages and doing the work of mechanical engineers and general contractors, also the work mines, coal timber. So whatever they were doing the business of railway wagons, trying to make those railway lines and railway tracks, everything engineering contractors kind of work they're doing. It's nowhere mentioned that they're into the business of financing of anything. They're not providing finance. They're not financial institutions. They're working as a laborers, contractors, mechanical engineering kind of. So now this Mr. Rich has entered into a contract for financing for the construction of railway line. Later, when the directors found, they said that this is a wrong contract. They decided to repudiate the contract and said the company will not be held liable because this is outside the purview of the company. Company's major business is to hire and lend the railway wagons or to do the contractors kind of thing, mechanical engineering kind of thing. We're not into financing. So angry Rich went to the court and he said, no, now company made a contract with me and they are bound by them. So even if the majority of shareholders ratify, means even if majority of shareholders will agree, then also you cannot do anything which is beyond the powers of the company. Court was held that the contract was null and void. It is not within the power of the company to do such a kind of contract. Therefore, yes, Meera, now your comment is visible. Miss Meera Shinoy, if you have any doubt, you can ask it up. Okay, Miss Neha, no doubt. That's great. I'm glad we have other students also coming up over here. If you have any doubts, please feel free to ask your doubts because we are revising Companies Act and this revision is for you. So if you have any doubts, please ask me. Okay. Yes, Meera, your comments are visible. You can ask your doubts if you have. Okay, let me just complete this topic and then we'll move ahead to the doubts. So even if you have entered any contract which is outside the purview of the company, that is ultra vires, so it will be held null and void. Even if the shareholders try to correct it, means now the shareholders are saying, okay, we'll pass the resolution, we'll allow this financing, then also it cannot be done. A contract is not binding on the company, means it cannot become intra vires. Once it is outside memorandum, you cannot change it. Is that clear? Now let's move to the last topic of articles of association. I'll just give you 2 minutes break. Just go through this articles also. We'll have a quick revision of articles of association also. Meanwhile, just let me see if there are any more doubts on the other query session also. And you also, if you have doubts, you can raise your doubts. All right. Just go through, flip through the pages, whatever we have revised. Even you can see the MCQs, descriptive questions. Any doubt you have, you can ask me. Let's take a small 2 minutes break over here. Okay. All right. So I think you have gone through the same. Let's quickly finish it off with the articles of association also. Neha, you'll get to know about the same. As of now, we are preparing for September exams. So you will get the information from the admin for December or Jan classes also. Okay, don't worry. Now, articles of association, as you've already mentioned, it talks about the rules and regulations. Now, children, tell me one thing. If you're staying in a house, so whatever is happening inside the house, can your neighbors come to know about that? Am I right? Yes or no? They will not come to know because it is your house. You have maintained your own secrecy, privacy. A neighborhood will only come to know when you are screaming or shouting or such making noises. They'll get disturbed. Whatever you're cooking in your family, whatever you're eating, whatever fun activities you're doing, what movies you're watching, everything is happening internally. Similarly, memorandum of association is kind of a border that the company has formed. It's kind of a house kind of thing that you have formed. Whatever you are doing within that is your articles of association. You're making all the rules and regulations within the company, how the employees will be coming, what dress code they're following, how they will be joining the office, what are the timings, how they're behaving, what resolutions we need to pass, how the directors, everything is internally happening. So when we call by memorandum, memorandum is the outside border. So like your address of the house, everyone who is going outside can read the address because it's written outside. So memorandum is outside border. Everyone can read the memorandum. Although they can read your articles also, but any changes happening in the articles is your internal matter. So whenever anything happens beyond memorandum, company will not be held liable because company have already announced it as a public document. Both of them are registered with ROC and they kept open for public inspection. Anyone can read these documents and then only enter into contract with the company. However, in case of an articles of association, these are their own internal rules and regulations. As and when the company want, they can do such changes. So law says outsiders are not bound by articles. It is the domestic management creating rights and obligations between the members and company. So articles is something a very internal document. It is the business document and it has to be very strictly made between the obligations of the members. So anything which happens outside the articles, then outsider will not be held liable because it is the company's internal affairs. Company has to inform what changes they have made in their articles. Also, another line, they are the bylaws according to which directors and other members of the company are acting. So articles will contain regulations. They will include matters which are under the rules and regulations. Provision of entrenchment, many a times 2 marks question comes for entrenchment. Since we have time, I can explain you these 3 provisions related to entrenchment. Entrenchment means a very strict provision. Sometimes our articles include a very strict provision. Strict provision means generally a special resolution is required, which means 75% of shareholders say yes, then the changes can be made. But in case of an entrenchment, 90% of the shareholders, majority of the shareholders agreement is required. So if I want to make certain changes in my business, say for example, I want to pass a resolution to allow the members to certain thing, then that is a kind of entrenchment. I don't want the members to just do it on their own. We need 90% yes of the shareholders, then only this thing can be done. So if this kind of entrenchment provision can either be made on the formation of the company or by amending the articles. And also ROC has to be informed that we have included the entrenchment provisions. So these are the special provisions which company has a right to include, and thus in case of entrenchment, majority of the shareholders means more restrictive than these special resolution. Special resolution means 75% shareholders are saying yes, then also the things are fine. What is ordinary and special resolution? Again, CA enter second module, entire chapter of meetings, resolutions, you'll be understanding them. As of now, सिर्फ इतना पता होना चाहिए कि entrenchment means very strict provision. 90% of the shareholders need to say yes, then only those kind of alteration or changes can be made if entrenchment is included. All right. Also, ROC needs to be informed about the entrenchment provisions. The rest is very, very simple. So differences between memorandum and articles. Now, children, another tip I want to give you. Whenever examiner asks you about the points of differences, try writing the basis also. So try writing in a tabular form, write the basis, objectives, basis, foundation, relationship. What is the basis that you're giving? So this helps you to score a little better marks. So memorandum is your outer body and articles is within the rules and regulations. What is the relationship which is defining? Memorandum defines your relationship with the outside world. Article defines the relationship of company with it, within its members. Memorandum can be altered only as per provided in the Act. So section 11, 12, 13, it talks entirely about, and section 16 about memorandum and its alteration. However, and permission from RD and tribunal is also required. Our articles can be altered simply by passing an SR. And where do you need to pass entrenchment? If there is an entrenchment provision, then 90% of shareholders alteration is required. Otherwise, simply by passing SR means special resolution you can pass and your articles can be altered. Any acts done beyond the scope of memorandum are ultra vires and held void. They cannot be ratified, means they cannot be changed or accepted, even if all the consent of shareholders have been given. However, any act ultra vires the articles, you can simply pass a special resolution and you can amend. Is that fine? Now again, since it is your revision, you have read it, you have revised it. So quickly tell me, what is the meaning of doctrine of constructive notice? What do you understand by the doctrine of constructive notice? Only this line you have to underline in this paragraph. Rest you can avoid reading. And this word also, public documents. MOA and AOA are public documents. Any person dealing should inspect them and make sure he knows what they're dealing. Otherwise, any person who is dealing with the company is presumed. Presumed means मान लिया जाएगा. It will be presumed that you have read these documents while you're dealing with the company. That means you have a constructive notice about it. Any person who entered beyond the powers of the contract, then that person will be held liable, not the company. Very good, very good. Correct, Yukta. What about others? What is the meaning of doctrine of constructive notice? Others don't know the meaning. Do you know now? Now you know the meaning that they are the public documents. All right. Miss Meera Shinoy, what is the meaning of doctrine of constructive notice? Okay. So doctrine of constructive notice means that MOA and AOA are public documents, and anyone who is dealing with the company, we assume that this person who has come up has read these documents before coming and dealing with us. Now, doctrine of indoor management is an exception to constructive notice. It says what is happening now. Now, coming back to the story of that house I was explaining, whatever you're doing within that house is your internal affairs. Outsiders will not have the notice of what changes you are making within the company. If any act is authorized by articles or memorandum, outsider is presumed that all the detailed formalities have been done. The leading case law over here is Royal British Bank versus Turquoise. It is also known as Turquoise rule. Now, this is very, very interesting case law and very important as far as the doctrine of indoor management is concerned. Children, indoor management, as the name suggests, that the door is closed and whatever is happening indoor. Outdoor tha memorandum. Outdoor, it is open to the public and they know. Then it is outsiders for. So doctrine of doctrine of ultra vires, you can write down this line. In case of doctrine of ultra vires, outsiders will be held liable. Doctrine of constructive notice, you tell me who will be held liable, outsiders or insiders? Yes, all the students are live with us. Very good. Outsiders will be held liable. And in case of doctrine of indoor management, किसकी गलती है? Insiders की, outsiders की? In case of doctrine of indoor management, company, that is insiders, will be held liable. Very good. Correct, Yukta. So this is very, very important. You should know that in what doctrine who is considered to be held liable. All right. So now let's discuss the case of Royal British Bank versus Turquoise. Now, Turquoise was the official manager, that is the liquidator of the company, and the company was formed in 1844 under the Act of 1844. Now, what is relevant information? We are only going to read that for us. Company has given a bond of 2,000 pounds to the Royal British Bank on the basis of security of company's drawings on current account. Now, children, company can be given bonds, acceptance of deposits can happen. Now, what has happened? Company has raised a bond of 2,000 to Royal British Bank, and the security has been given on the current account. So the company's current account has been made secured against a bond of 2,000 pounds. And the bond was signed by two directors and a company secretary. When the company was sued, it was held that the registered deed of settlement directors had the power to borrow only up till the amount which was authorized by a company resolution. And the resolution was passed, but it has not specified how much amount the directors could borrow. Now, what happened? There was a company which has borrowed the money. Turquoise is the liquidator of that company. Turquoise, the case was filed against the liquidator, children, not against the company. So Royal British Bank has filed a case against the liquidator who was managing. So what would have happened? The company would have went into liquidation. And then whenever the company goes into liquidation, a liquidator is appointed who will take charge of all the assets and will dispose of the assets and pay off the liabilities. Now, while he was disposing of the assets, he came to know that the company has, directors have borrowed a money of bond has been signed with the bank for 2,000 pounds. But when he went to the papers of the company, it was written in the company that the directors have the power to borrow money. A special resolution was passed up till that effect. But how much money can be borrowed, that was not specified. So later on, they said that you cannot enforce this. We will not be paying you back this money because this bond is not valid. So angry Royal British Bank filed a case against them. Again, it was a Supreme Court judgment and case was filed against them. And it was held that Royal British Bank said, how do we know whether the company has decided the amount or not? We are only supposed to know that the company has passed a resolution and that we have read. But whether you have specified the amount or not, whether your directors have the power or not, that is your internal matter. So in this case, the Royal British Bank won the case and the company was held liable. Why? Because internal affairs are the company's internal management. So he could enforce. Bank was deemed to be aware that directors could borrow. They said that we are aware that directors can borrow. Articles were registered. We had the constructive notice. Bank was not required to know how much, whether the order resolutions have been passed. Bond was valid because there was no requirement to look into the company's internal working. It is indoor affair, indoor management, company's problem. So that is why in indoor management, please write down in your notebooks, doctrine of indoor management gives a protection to the outsiders. Doctrine of indoor management gives a protection to the outsiders. Any changes made in the company's internal affairs, outsiders are not bound to be held liable. Company will be held liable. Okay. Now again, constructive notice, outsiders are held liable. Exception is companies held liable. Now, it says that company is acting through its directors and other persons. Sometimes that particular person is at fault. You cannot hold the entire company liable. So there are 3 to 4 major exceptions to this rule also. That is exceptions to the doctrine of indoor management. So in Turquoise rule also we can say, or indoor management, it is one and the same thing. The first exception is the rule will not protect the person who has the notice of irregularity or constructive knowledge of irregularity. So where you know that something is happening is not a suspicion of irregularity. You are doubtful about something. Say, for example, a director had the power to borrow up till 2,500 pounds, but he's still borrowing up till 3,000 pounds, and you are aware that he cannot borrow beyond, then it is your fault as well as that director's fault. Then company will not be held liable. So where you already have a suspicion of irregularity, there you cannot hold the company liable. With the directors, let's read this case now, where the directors could not defend the issue of debentures to themselves to the extent they were lending money required the assent of general meeting, which they had not obtained. So directors knew that the assent of the general meeting has to be obtained. They cannot issue the debentures without that. Then it is director's responsibility. It will not be the responsibility of company or outside. Similarly, a director could not defend an allotment of shares to him as he participated in the company which made the allotment. His appointment as director also fell through because none of the appointment directors him was validity in the office. So none of the doctors appointed him as was a validity means if there is something which is happening as a mismanagement on your end, then that director will be held responsible. All right, you cannot hold the company responsible. Otherwise, doctrine of indoor management company responsible hoti hai. But first exception mein, where you know about the irregularity, that particular director or the officer will be held liable and the company will not be held liable. Suspicion of irregularity. It says where you have a doubt in the ordinary course of business, then also Turquoise rule is not applicable. The leading case law is Anand Bihari Lal versus Dinshaw and Company. Here, the plaintiff accepted a transfer of the company's property from its accountant. So, children, you will understand that the accountant of a company he's not the owner of the company. He does not have a right to sign the transfer deed. Can an accountant sign upon the transfer deed and can transfer the company's property to another person? Now, this plaintiff is accepting the transfer deed, proper transfer papers of the property from the accountant. So here this person is at fault, that accountant is at fault because you're doing a wrong thing. Accountant never has the authority to transfer the company's property. And the last one, Rubin versus Great Fingal Consolidated Limited, talks about the forgery. MCQ में क्वेश्चन बहुत बारी पूछा जा चुका है और पूछा भी जा सकता है कि इंडोर मैनेजमेंट में फोर्जरी अप्लाई होता है या नहीं. So indoor management or Turquoise rule will not extend to forgery. If any, say for example, the plaintiff held that the transfer of share certificate fixed the seal of the dependent company secretary who has fixed the seal and forged the signatures of two directors. So generally the company secretary was supposed to sign and two directors were supposed to sign. And what did this company secretary say? She made her own sign, and for the directors, she has done a forgery, means she has given a fake signatures. So such a transaction will also be held void, and that particular company secretary who has made this forgery kind of thing will be held liable. So Turquoise rule is never applied to forgery. Company will not be held liable because any transaction which is forged will be held null and void. Is that clear, students? So here we come to an end of the Companies Act 2013. We are well in time. We have completed the syllabus. So it has been a quick revision and we have revised almost all the topics. We can see certain MCQs also since the time permits. So document that regulate the management of internal affairs are memorandum, prospectus, articles, or the certificate of incorporation. Please give me the correct answer, students. Very good. Nobody is going to cheat and give the answers. Please give the correct answers. What is the number of members in case of a private company? 20, 50, 200, 150, no limit. Very good. 200 is the correct answer. Okay. Which of the following is not the content of memorandum? Name clause, registered office, object clause, board of directors clause. Yes, Meera. Answer. Ishika, correct. Neha, correct. Ishika, exception to constructive notice. Are you asking certain question or you have understood it? Very good, Yukta. Board of directors clause is wrong. Tanishka, you are also correct. Turquoise rule is related to ultra-wise constructive notice, indoor management or subrogation. Very easy question. Indoor management. Very good. Correct answer. All of you have given the correct answer. Okay. Only a natural person who is an Indian citizen and who stayed in India for at least dash days during the immediately preceding financial year can incorporate OPC. 180, 181, 120, and 183. What is the correct answer? $120 is the correct answer. Very good. Now, my question is, he appointed Mr. X as the nominee for this OPC. And this Mr. X stayed in India for 3 months in the immediately preceding previous year. Can Mr. X be appointed as the nominee? Yes or no? Anushka, Neha, Ishika, Meera, all correct. All of you are correct, children. Can he be appointed as a nominee? Very good, Tanishka. Yukta, no, ma'am. Why? Because he should have stayed in India for 120 days. Then only he can become a nominee. Very good, बच्चों. आपको समझ आ गया मतलब. Very nice. XYZ is having 15% share capital held by X Limited, 50% held by government, 10% held by state government, 25% by other people. What is this company? Government company, public company, private company, or dormant company? What will you call this company where the 50% central government is holding, 10% state government is holding? So more than 51% is being held by government. So very good. It is a government company. Correct. See, what is a government company? What are the similarities and dissimilarities? Such a simple question. So guarantee company, you have to tell guarantee company are the kind of charitable organization, mention the points of uh, fees, charities, donations, endowments that they get for running a company. Similarities are both of their liabilities mentioned in MOA. Dissimilarities are guarantee company winding up में उनकी liability pursue करते हैं, company having share capital, their liabilities arising only during the time of continuation of the company. Second question relate to which section? Quickly tell me, can a non-profit organization be registered as a company? If yes, what is the procedure? Yes or no? Question number 2, which section is applicable? Excellent. Section 8 companies. Yukta, Tanishka, very nice. Third and fourth questions are also very, very easy. Samiksha, yes, please tell me a doubt. Okay. She's asking, ma'am, I have a doubt in chapter of partnership that partner by holding out can demand for profit. So partner by holding out child is a partner by estoppel. So where the person is not an actual or real partner, but he has presumed himself to be acting as a partner in a firm. So for only that particular transaction, number one, he is held as a partner. So for that transaction, generally it is a case of liability where he'll be held liable to the outsider. In case any profit is arising from that particular transaction, that he can claim, but he will not become a regular partner in the firm. All right, Samiksha, I hope it is clear to you. समीक्षा प्रजापति. ओके ओके, वेवर वी हम क्या बात कर रहे थे? हाँ, सेक्शन 8 बिल्कुल ठीक बोला आपने, इशिका, नेहा, ऑल ऑफ यू आर करेक्ट. Assessee had the income in the way of dividend and trust. And question number 5 relates to what point? जल्दी से बता दो मुझे. Question number 5 relates to what point? Cheating करे बिना you have to tell me. Ishika, Tanisha, Yukta, Neha, all of you quickly answer me. Can he be regarded as separate? It relates to, very good, it relates to Dinshaw Manekji Pettit case law, where he is dividing the company's credit line. Salomon, Tanishka, no, it is not Salomon. It is Dinshaw Manekji Pettit wala case, where we have discussed about the corporate bail theory. Corporate bail theory is Salomon, but this question number 5 relates to your Dinshaw case, where he's divided the income into 4 different companies and giving them income and taking a loan from them. Then he will not be regarded as separate. He will be regarded as one company. Question number 6 relate to what point? Sound indicated a public company, its articles empower the managing agent to borrow short-term and long-term loans. Director approached the non-banking financing for the loan of this much amount. Loan was agreed and later on this company fails to repay the loan, saying that no resolution was passed. So analyze the above situation. It is very clear case of doctrine of indoor management. Here the contentions will not be held. Correct. So question number 6, very good. Tanishka correct now, indoor management case. Let's read question number 7 also quickly. This is the last question, I believe. Okay, let's read question number 8. A company being an artificial person cannot own property and cannot sue or be sued, whether it's correct or not. It's A, correct or not? You're welcome, Samiksha. Any other doubts also, children, you have, you can ask me. Ishika, very good. Rincha was the correct name. Mr. Akash, your answers were also correct. Anushka, your answers were correct. Neha is also typing correct. Meera, where are you, Meera? Very good. Incorrect, because company can own property and can be sued. A private limited company must have minimum 2, while a public limited company must have at least 7. So that is absolutely correct. You all know about that. Let's take up this case of Naveen Incorporated OPC making a sister Navita as the nominee of the company. Navita is leaving permanently India due to her marriage abroad. Due to this fact, she is withdrawing her consent. So he is leaving, he is making his sister as the nominee. Navita is leaving India permanently. She is withdrawing her consent of nomination. Taking into consideration, answer is Navita leaving and mandatory for her to withdraw. Tell me the answer for 7th question, A part quickly, children. You have to give me the answer for the 7th part. Can he withdraw his consent? Miss Khadija Puchi, yes, you can ask any doubts if you have, beta. You can ask over here. Even if you're a new student, if you want, we're doing Companies Act revision. Even if you have any doubts, you can ask the doubts here. Yes, let's quickly study the answer for this, how you have to attempt. Yes, it is mandatory. Ishika, Neha, Anushka, all of you have given the correct answer. Let us quickly see how you have to attempt such questions. Yes, it is mandatory to withdraw as she is leaving India permanently, as only natural person who is an Indian citizen and resident in India can be nominated as an OPC. So since he is not here, he can withdraw her nomination. Can he continue to be if she has maintained the status of residential? Now, if you're not a residential status, you're leaving India, so you will not be fulfilling the conditions of 120 days. Anyways, she'll have to mandatorily withdraw her consent. So if she has maintained the status of, so before marriage, if she has been staying for 120 days, then she can be still nominee, but child, he will be nominee only for that particular year because he's saying he's leaving permanently India. So next year again, definitely she will not be here for 120 days. But if she decides to come here for 4 months, she's staying. So these kind of questions, always presumptions have to be given. So you can say, yes, she will not be continuing because she has maintained her status. She's staying for less than 120 days. Then no, she will not be nominee. She has to withdraw her consent. So always your answers should have certain logics. Whatever you're saying should be correct. Yes, Tanishka, your answers are correct. All your answers have been correct, children. Yukta, correct. I have read all your answers. Somebody has written false. Yes, incorrect. That was correct answer. Good. So with this, we come to an end of your company's act revision also. Ishika, correct. Yes, Samiksha, that's correct because it's mandatory. So I hope there are no any other doubts. Even if you have, still you have any other doubts, I'm here for 1 minute more and you can ask me. Otherwise, all the best for your September exams. Please keep revising, keep making notes. Don't be overconfident also. At times we feel that we have studied it and now I know everything. Revision is very important. So when I say being consistent means you have to keep revising your content again and again. Then only it's get fed over here. Because children, over the period of time, you have done so many things. बहुत ज्यादा हो जाता है syllabus, so you have to retain it. So retention is very important. So contract act has been now ages that you have studied, so start revising from the contract act. Many times you get twisted questions from Indian contract act. So after completing your entire syllabus, you should start again from the contract. Sale of goods also, sale of goods and partnership is very very scory. Refer to the recorded lectures once again, refer to the revision lectures, revise your contents and keep making your notes. All right. So I don't have any more queries. I hope you enjoyed the session. Thank you, Ishika. Thank you so much. Thank you, all of you students, and do well in your exams. All the best. Thank you so much. Thank you, Yukta. Thank you. Thank you, Tanisha.